The Socioeconomic Rights and Accountability Project, SERAP, has dragged President Bola Ahmed Tinubu to court over what he calls the unlawful suspension of the Rivers State Governor, his deputy, and the House of Assembly members. SERAP argued that the decision of the president violates constitutional provisions and undermines democratic governance. The Attorney General of the Federation and Minister of Justice, Lateef Fagbemi, and Vice Admiral Ibokete Ibas have also been joined as defendants. The suit is seeking an order setting aside the suspension of democratically elected officials in Rivers State by the president and an order setting aside the appointment of Vice Admiral Ibokete Ibas as the sole administrator of Rivers State. SERAP, in a statement by its Deputy Director, Kolawole Oluwadare, said, quote, "The rule of law will be a mere figure of speech if the people's right to participation can be arbitrarily suspended or violated," end quote. SERAP insists that the suspension contradicts both the Nigerian Constitution and international legal obligations, citing the African Charter on Human and People's Rights and the African Charter on Democracy, Elections, and Governance. All right, Frank Tietie, a lawyer, joins us, and a Rise News analyst, joins us in the studio to look at some of these issues that I just read out to you. Frank, glad to have you join us. Well, let's start this. The presidency says they've been responding. Of course, one expected that the president exercised his powers under Section 305 of the 1999 Constitution. It interprets a state of emergency as a situation of one, national danger, two, disaster or terrorist attacks, where the state government is unable to operate properly. Did what the president did meet these requirements?
Well, the president is the commander-in-chief of the Nigerian Armed Forces, and in that he has exercised his powers under Section 305, and we have witnessed a gale of disagreement and condemnation with regards to the president's decision or proclamation of a state of emergency. Unfortunately, what the president has declared and done is stands. Sadly, the governor of Rivers State and the members of the Rivers State House of Assembly have all been suspended. And there is no authority or person in the Federal Republic of Nigeria at this time that can challenge the powers of the president. The president has made such declaration and deployed the forces of government to go and effect it. One would have expected that if the president would submit himself to the authority of the Constitution, then the proper institution that would give a different order or give a different direction to the president would have been the Supreme Court. If the Supreme Court hasn't given any direction to the contrary, unfortunately, the president's declaration stands. And that's where we are. We appreciate the fact that we are in a democracy where we have various manner of opinions, and they have been so expressed. And the presidency couldn't in any way ignore the opinions of former President Goodluck Jonathan, or a man who had, somehow supported President Tinubu at a time where many people had their doubts, and I'm talking about the Nobel laureate Wole Soyinka. If he's at this time condemning the action of the president, then there really needs to be a rethink. Unfortunately, the president becomes a law unto himself in a matter where there's no provision of the law, because the Constitution itself, sadly, unfortunately, did not define the extent to which the president can exercise his powers in a situation where he declares a state of emergency. Where the Constitution could have done that is simply referred the declaration of the state of emergency to whatever the president does in exercise of his powers under Section 305.
All right.
So we're in a secular situation.
All right. Well, just like you said, people have been commenting. I know that the author of the School of Thought, Dr. Sam Amadi, talked about that in fact he advised the Fubara to go to court. Now SERAP has gone to court and joined Admiral Ibokete Ibas, the administrator. He has joined the Minister of Justice, Lateef Fagbemi, in this as defendants. What do you make of this action on the side of SERAP?
Okay, so the advice or recommendation of my learned senior Dr. Sam Amadi, perhaps will not hold water considering the decision of the Supreme Court in the matter of between Plateau State government and the Attorney General of the Federation with regards to the declaration of a state of emergency by the former president Obasanjo when things got out of hand and there was actually breakdown of law order in Plateau State. It's so funny that the court decided that wherever in a state of emergency, as when the governor has been suspended, he couldn't in any way exercise authority to sue in the name of the state. Perhaps he can go and sue in his personal name. In that case, he will have to start from the court of first instance, in this case, the Federal High Court. But you see, there are two things here, because this SERAP issue that is coming in, because it's important that we don't waste opportunities like this. In 2006, in the case between Plateau State and the Attorney General of the Federation, very salient and important issues were raised before the Supreme Court, which could have actually laid down the principles and delimited the powers of the president whenever he declares a state of emergency. Unfortunately, that case was thrown out against the Plateau State government because they didn't, they lack local standard, in the sense that there was no authority. That Chief Dari at that time was suspended, so he couldn't have exercised the powers of Plateau State government to to invoke the original jurisdiction of the Supreme Court under Section 232 of the Constitution. Now, in this case, SERAP takes an undue risk, and the risk of wasting this precious time in approaching the court when it knows that it suffers, according to many commentators, in a short while ago, that it suffers the danger of not having local standard. And interestingly, one would have also expected that since the PDP governors have taken a proactive stance, and I'm very happy someone brought it to my attention this evening, because I had, raised issues and wondered so loudly why the governors of Bayelsa State and Delta State, who are closer, or rather closest to the River State, have not also considered to direct the Attorney General to go and instill a matter in the Supreme Court. Because let me tell you something.
Would they themselves, as against SERAP having a local standard?
Oh, yes, yes. SERAP only suffers that danger. We want to sit here really and take a decision, but we know from previous decisions of the Supreme Court, and it doesn't. So it doesn't look as if SERAP is not an organization that is looking for cheap popularity. If it's for young lawyers who want to be known and they are filing all sort of frivolous cases, one won't understand. But you see, you can predict certain things. You can know that you know the mind of the court because of the stare decisis principles that we practice. So you would have expected that perhaps that should have waited and allowed the PDP governors, because they issued the PDP governors forum actually issued in a communique that they would direct their attorneys general to approach the Supreme Court. And let me tell you the difference. The difference is this: under Section 232 of the Constitution, whenever a state government has any dispute with the federal government, he can bypass the Federal High Court and the Court of Appeal and go straight to the Supreme Court to have the matter heard. That was how the jurisdiction of the Supreme Court was invoked during the Naira redesign case, when Kogi State and Kaduna State went straight to the Supreme Court and the matter was resolved. So in this case, if it would be difficult for Governor Fubara to approach the Supreme Court, because the danger is that he actually refer to himself as a governor when the president has proclaimed a suspension. However, he's a personality. I mean, votes have been given to him. Does it mean he doesn't want to defend the mandate, the constitutional mandate of that was given to him by election? Or if that is going to suffer any deficiency, what about his brother governors in Bayelsa, particularly in Delta, who are also governors of oil-rich states that are also likely to be very volatile, considering the nature of the kind of oil politics and the kind of politics the people play? One would have expected that the attorneys general of those two states would approach the Supreme Court. And there is a promise already by the two state governors, even though there are rumors that they are delaying because these governors are also sympathetic to the NPC. Rumors, I will say in emphatic terms, that they may not necessarily want to challenge the president at this time. But it is important that the governors who are likely to be the next victim of the president's big stick, because as it is now, the president is wielding unusual powers. Several things have happened in River State. Pulling down the River State House of Assembly complex, and then a lot more mayhem happening. The president didn't do anything. Just a trigger of a pipeline being burst somewhere and there, and then the president...
Even now, recently there was an explosion.
So the president, there is danger, because what it means is that in Delta State or in the Bayelsa State, the president is looking, and if some persons are causing trouble and the governor is unable to invite the president quickly to come and take over, the president can also proclaim a state of emergency.
The president can be running riot like a referee in the field who flashes a red card.
Let me tell you, the president says he is a custodian of peace, good governance, and some measure of public order in this country. And interestingly, the president wouldn't bother so much about northern states if they are in turmoil, but he will bother very much about River State, Delta State, and Bayelsa State, because these are the control, these are oil producing states. And so the president, so those are the governors who should be really worried. Who should act, because if the president declares a state of emergency today, many people are so crossed with the president that why would you suspend the House of Assembly? Why would you suspend the governor? Particularly when you consider section 305, subsection 3, paragraph C, where it is expected that, paragraph D, I would say, where a governor can actually invite the president, please come and declare a state of emergency in my state. Are you saying the governor is inviting the president to come and sack him? So we need the Supreme Court to come and actually interpret this. Unfortunately, the persons who should go there are slacking. That's why SERAP is trying to, and I think SERAP should have waited a bit and allow the governors of those states to make that application to the Supreme Court.
Frank Tietie, Arise News analyst. Thanks for being here to discuss this issue. Thank you.